Just let those two settle. All right, hello everybody. I want to welcome to our meeting of the Standing Committee on Economic Development and Environment. We'll get this evening's proceedings started off with a prayer, and I'll ask everyone to rise and have Mr. O'Reilly lead us in prayer.
Thanks, Mr. Chair. If you wish to experience peace, provide peace for another. If you wish to know you are safe, cause another to know that they are safe. If you wish to understand seemingly incomprehensible things, help another to understand. If you wish to heal your own sadness or anger, seek to heal the sadness or anger of another. Dalai Lama.
Thank you, Mr. O'Reilly. All right. As we mentioned, welcome everybody, and to some of you, welcome back for part two of the Yellowknife public hearings. We also have with us this evening Dene National Chief Norman Yakalaya is joining us this evening by phone, so we have him online. I'll take this opportunity to ask members to introduce themselves. I'll start with member from Hay River North.
Good evening, R.J. Simpson, Hay River North.
Kieran Tester, member for Cam Lake. Good evening.
Kevin O'Reilly, Frame Lake.
And my name's Corey Van Thyn. I'm the MLA for Yellowknife North, and I'm also the chair of the Standing Committee on Economic Development and Environment. We also have here with us this evening our committee clerk, Mr. Michael Ball, and as well our committee advisor, Mr. Stephen Dunbar. And I believe we also have with us working the cameras or what have you downstairs from our Public Affairs and Communications Division, Mr. Chris Cartwright. Today, the Standing Committee on Economic Development and Environment is holding a public hearing on Bill 38, the Protected Areas Act, Bill 39, Environmental Rights Act, and Bill 44, the Forest Act. The Standing Committee on Economic Development and Environment is a committee of regular members of the Legislative Assembly. The bills we are reviewing today were introduced by the Minister, given first and second reading in the Legislative Assembly, and then referred to this Standing Committee for review. Legislation is typically brought forward by Cabinet and is reviewed by Standing Committee. The members of this committee are responsible for holding the government to account, and one of the ways we do this is by making sure that proposed laws are supported by the people of the Northwest Territories. It is our responsibility to consult with residents on what they like or don't like about the bills. We would like to hear your views and comments, which will be used by the committee to identify any changes we would like to see made to the draft legislation, and which we will then report back to our colleagues in the Assembly. The Standing Committee held public hearings on these bills in Fort Smith, Catlow-Deechee First Nation, Hay River, Fort Providence, Betchico, Inuvik, and Norman Wells before holding our final meeting here in Yellowknife. The other evening was part one. This evening is part two. We then report back to the Legislative Assembly on the proposed legislation during the upcoming sitting in August of the Legislative Assembly. I wish to briefly describe the intent of these bills. Bill 38, Protected Areas Act, proposes to establish new legislation that will allow the GNWT to create permanent protected areas in the NWT where there are important plants, animals, land, cultural, or historical sites. It also allows for co-management of a protected area with an Indigenous government or organization. This bill says what is allowed to happen in protected areas and what is not allowed. Mining exploration, oil and gas development and exploration, and energy developments are prohibited. Small-scale renewable energy projects may be developed within a protected area or by an adjacent community. Roads or power lines may be permitted with consultation of the Protected Areas Management Board. Bill 39, Environmental Rights Act, proposes to change the existing legislation by protecting people's rights to a healthy environment, help ensure the GNWT always considers how the environment could be affected, and investigate when a person reports to the minister that someone has harmed or could harm the environment. Gives residents of the NWT tools to help the GNWT protect the environment. The GNWT must write a report every 4 years on the state of the NWT's environment, which will be reviewed by the Legislative Assembly and allow time for public comment. Bill 44, the Forest Act, proposes to establish new legislation that will provide tools for managing forests and the use of forests in the NWT to keep them healthy, provide tools to prevent and respond to wildfires, create forest harvesting agreements, permits, and licenses, allows the GNWT to create rules around harvesting timber and create rules on burning outside communities, allows the GNWT to create rules of harvesting of other forest resources such as berries, mushrooms, or other plants, respond to insects, invasive plants, and forest diseases. For those who haven't already helped themselves, there are copies of the bills and plain language materials on our side table here, so we encourage you to please help yourself. And I believe for most people who care to share their views with us today on any of these bills, we already have you on a list. So I'm going to just quickly read out the names that I have, and it's likely that we'll present in this order. I have Dene National Chief, Norman Yakalaya, Sarah Brown with NWTAC, Nick Gleason with Sawtooth Renewable Resources Board, Matilda Becker, Zoe Zoe Guile, and is that with CPAWS? Yes. Okay, with CPAWS. And then I have Lois Little, Council of Canadians, NWT chapter. Is there anyone else who wishes to speak this evening? If there are...
I'll be supporting Zoe.
Okay, and we'll call you both. You can both come up to the witness table at the appropriate time. All right, so then we got everybody that will be speaking this evening. One final piece of housekeeping. Please remember that all submissions will be part of official committee records and may be reflected in our final report. Any submissions made during this meeting may also be televised or broadcast via social media, as it is this evening. So, thank you everyone for your patience in allowing this introductions. With members' agreement, we can now open the floor to comments from the public. Do members agree? Thank you, members. Without further ado, Dene National Chief, Norman Yakalaya. Chief Yakalaya, are you on the phone?
Yes, I am.
Okay, I will turn it over to you.
Thank you, Mr. Chair. Thank you, committee members, staff, and guests at the committee A room. I just want to say, Mati Sotene, so. So, Mr. Chair, I said, thank you, my people, and it's beautiful outside. And just to let you know that on my cell phone here, I'm on the red line of my phone going out, so I'm going to save my piece, and hopefully I have enough charge time to answer any questions from the committee members. And if I get cut off, it's because I didn't sufficiently charge my cell phone. So, Mr. Chair, thank you. There appears to be general support for Bill 38, or at least no clear opposition from the Dene leaders. There's general support for Bill 39, protective areas. There is an interest from the Dene leaders of seeing this bill pass. However, in Bill 44, there are significant fundamental process flaws with this bill, with the co-drafting. The bill was drafted with no significant co-drafting from the Indigenous leaders or by the Indigenous governments. A full co-drafting process similar to the process used for and the Species at Risk Act would have avoided the current situation we are in with this bill as presented by the government. The main issues, which is a rights issue, is the requirement of permits for harvesting of forests, unlike harvesting related to fishing, hunting, and trapping, where permits are not required. It is our treaty right and our land claim agreement right. There are significant requests for amendments related to the forestry bill that will be brought forward to this committee for their support by the chiefs and their officials, as you have noted through your travels and continue to note from your other visits. Mr. Chairman, we are not stakeholders. We are a nation of governments, and as such, we are committed to working with the current flawed process to suggest significant amendments be made that will address the concerns of the Dene and the regional governments, so this bill can be supported and passed with the support of the Indigenous government. We ask this committee listen closely as he travels to the communities, and he'll hear common concerns, requests for such amendments. We ask this committee to support and recommend these requested amendments to the GNWP for their concurrence. We will wait and watch the outcome of this process, which we will determine whether or not we support Bill 44 when it's brought forward to the third reading, or that it be pulled for the next government to deal with. We'll be pursuing a formal commitment to a full co-drafting process on bills identified by the Indigenous government, working with the GWT and the Legislative Assembly as legislative priorities are agreed to the 19th Legislative Assembly. Mr. Chair, those are my comments. Thank you.
Thank you, National Chief Yakalaya. Committee, I'll turn it over to you if you have any comments, questions, concerns with National Chief Yakalaya's presentation. Mr. Testart first.
Thank you, Mr. Chair. Thank you, National Chief. I appreciate you taking the time to speak with us today. We have spoken to many Indigenous leaders and their government representatives over the course of our consultations outside of Yellowknife, and many of the issues you addressed tonight have been brought to our attention. The thing I am most seized with on this issue is the nature of the co-drafting agreement that the government signed with Indigenous nations as part of the Devolution Accord, and that seems to have not been done, at least not done to the satisfaction of all parties, which is kind of the point of this very important tool of reconciliation. So my question is, you mentioned several times that this was a flawed process. Is it your position or the position of the Dene Nation that this bill should be restored to the proper process as outlined in the Devolution Agreement? Thank you.
Thank you. National Chief Yakalaya.
Thank you, MLA Testart. Our position is that this bill, specifically Bill 44, the Forestry Act bill, should be both hands on the pen with the co-drafting as they did with the Wildlife Act and the Species as Risk Act. That process, when I was the MLA at the time, that the then Minister Milsenberger what process where both the government of the Northwest Territories and the Indigenous government went through that process of co-drafting that bill with all support from the Indigenous government. And this Bill 44,
National Chief Yakalaya, can you try to reposition your phone a little bit?
Yeah, and how is this, Mr. Chair?
That's much better. Thank you.
Yeah, I'm just outside of a restaurant at Big River, so trying to get that signal if possible. Life on the road, like an MLA. So, I want to just say that the flaws is in the co-drafting. The indigenous governments were not involved with the co-drafting. Only the government of Northwest Territories' hand was on the pen of the co-drafting. We had the Wildlife Act and the Species as Writs Act, both pens were on the co-drafting process. And that was the significant flaws in the Bill 44. And I apologize, MLA Tessar, and I didn't quite hear your question on the resolution question.
Thank you. For clarification, Mr. Testart, try to speak up a little.
Yeah, sorry. Thank you, National Chief. I think you answered my question quite well. I just, I want to remind everyone here that the legislative process is not, bills, there are many things that can happen to a bill. A bill can be amended, a bill can be defeated, a bill can be withdrawn. And given the significant issues you've raised, this committee has different tools available to us, including recommend that the bill not proceed. My greatest concern is that now that it's come this far, we can certainly recommend amendments to the bill and propose amendments, but the minister has a veto over any amendments we propose. So those agreements need to be negotiated. So our ability to improve the legislation to the satisfaction of Indigenous partners is limited by that veto and by the scope of the legislation itself. So we're going to have to work very carefully and diligently to try to do our best job. But I can state for the record that I'm not inclined to support the bill continuing on if it can't be improved along the lines that committee recommends and along the lines of the concerns raised by Indigenous governments and nations. So thank you very much for your time this evening. It's much appreciated. Thank you.
Thank you, Mr. Testart. Next, I have Mr. O'Reilly.
Thanks, Mr. Chair, and thanks, Chief Yakalaya, for doing the call from Big River. I guess it sounded like you were reading some notes, and I'm wondering if you could share those with us or with the clerk of the committee, and whether there might be, do you know whether there might be a written submission in addition to your presentation this evening? Thanks.
Thank you, Mr. O'Reilly. National Chief Yakalaya.
Thank you, Mr. Chair, and thank you, National Chief Norman Yakalaya.
I guess his battery died.
Either that or he didn't want to talk to me.
We'll never know.
So maybe, Mr. Ball, if you can just make an attempt to see if you can contact him again and at least ask the question, and if he can even just answer you would be good to know. So, well, that's the end of that presentation. So, Mr. O'Reilly.
Thanks. Yeah, just for the benefit of those that may be watching or listening, the way that the process works is there will be a clause-by-clause review of each of the bills, and that will be held in public, and that's where the committee and the minister meet in this room, and we will go through each of the bills clause by clause. Committee has the ability to propose changes to the bill, and if the minister agrees, they will be included in the bill as it moves forward. If the minister does not agree, they will not proceed at that point, but there is an opportunity for regular MLAs to introduce amendments on the floor of the House, but they will require a support of the majority of the MLAs to pass. So I think once the minister has been in here for clause by clause, people have a good sense of what the bill would look like, at least going forward to the House. So, and that there will be some time between the clause by clause review and when it ends up in the House. I don't know how long that period of time will be, but people have a sense of what the minister has accepted and what remains is perhaps unfinished business, and people, of course, are welcome to weigh in on their views about the amended bill moving forward. So I just thought it might be helpful, Mr. Chair, to outline that process.
Thank you,
Thanks.
Mr. O'Reilly, for explaining the process. All right, next presenter, we'll have Sarah Brown from the NWT Association of Communities.
Thank you very much, committee, and I really appreciate the opportunity for being able to provide you comments this evening and your persistence with listening to all of us over the 2 evenings. Appreciate that you're just as tired as we were by 9:30 the other night. First of all, we really have no significant concerns on the two other bills. Our primary comments are on Bill 44, other than that there needs to be a definition for what you mean by municipal within the acts. That does not capture all 33 communities. Municipal captures 24 of the 33, and if the intention is that all 33 communities have the opportunity to participate effectively within those acts, that does need to be clarified. Our primary concerns, as I mentioned, are with the Forest Act, and along with the other acts, we have the similar comment about capturing all community governments. We recommend that language. Also, too, it does not specifically speak to municipal governments or local governments or community governments participating in a very effective manner. They talk about public, and while community governments are part of the public, they are actually a level of government and should be recognized as such. We've had quite a number of items that have come up where we were just told, we'll just comment during the public process or fill out a public survey, and that is not appropriate when it has significant impact on the community governments. So we are concerned with that on the Forest Bill. Community governments are often actively participating in fighting wildfires, particularly at the interface of the community, in and around their communities, as well as fire smarting. So they need to be part of these discussions, and that is definitely missing in the Act. There is also very little reference to community governments in the Act at all. They should, at a minimum, be actively consulted on the following activities that impact on the community or are, whether they're close to or within community boundaries. That would be wildfire prevention and preparedness plans, forest harvesting agreements, permits and licenses, closed areas, fire bans, and any associated appeals or amendments to the above. Once again, I'd like to thank you for the opportunity to present, and that you're doing actually a very comprehensive review, and we certainly appreciate that.
Thank you. Thank you, Ms. Brown, for your presentation today. Comments, questions from committee? I'll start with Mr. Testart.
Thank you, Mr. Chair, and thank you, Ms. Brown. So Section 16 of the Act under the Bill 38, protected areas, has a definition of adjacent community, and it says for the purposes of this subsection, the applicable government of an adjacent community is if the community is a municipality, the municipal council, or if the community is not a municipality, the community council or band council responsible for the administration of the community. I know you were mostly speaking to Bill 44, but for Bill 38, does that satisfy the concerns of the NWTAC? Thank you, Mr. Chair.
Thank you. Ms. Brown?
Thank you, Mr. Chair. Yes, it does, but it should be consistent across the acts with that consistent definition, I think would make them all stronger.
Thank you. Nothing further. Next, I have Mr. O'Reilly.
Thanks, Mr. Chair. My colleague took my question, one of my questions, but the peculiar thing is I don't think communities are even referenced in the community governments or even referenced in the Forest Act. But I want to thank you for your presentation, and you have a copy of the letter and your list of bulleted items that you would like to ensure that community governments are consulted on. There's one other that I might ask you about if I can, and that's forest ecosystem management plans. Those are discretionary under the bill, The supervisor, as I recall, may prepare these forest ecosystem management plans. And of course, they could conceivably cover areas even within municipal boundaries. Is that something that NWTAC would want to ensure that community governments are consulted on? Thanks, Mr. Chair.
Thank you, Mr. O'Reilly. Ms. Brown?
Yes, thank you, Mr. Chair. Absolutely. As much as possible, the adjacent community should always be consulted. They're part of the planning exercise. As you mentioned, they may in fact be impacted by planning and zoning that are within the community as well, and those are absolutely critical that the communities are included.
Thank you. Further, Mr. O'Reilly?
Thanks, Mr. Chair. That's helpful. And so I just want to be clear, it's the request here is not just for notice to be given, that you want to ensure that community governments are actually consulted. I guess one other question, if I can, as I understand it, with the Forest Act, there's no requirement that I can see for a public registry or any way to find out about the administration of the Act. Do you have any views on how the public, and including the NWTAC community governments, might find out about approvals, permits, licenses, and so on under the Forest Act? Thanks, Mr. Chair.
Thank you.
Thank you,
Ms.
Mr.
Brown?
Chair. It sounds like something like a registry might be the most effective way to do that, but I think that expecting directly impacted community governments to have to go and be keeping track of a registry is inappropriate, that they should in fact receive appropriate consultation and notification directly to those councils and to those senior administrative officers. They're all extremely busy, multitasking individuals, and that expectation that they are doing that outward look is quite inappropriate.
Thank you. Nothing further? If there's nothing further from committee, thank you, Ms. Brown, on behalf of the NWT Association Communities for coming and presenting. Next, we'll have Nick Leeson, representing Sawtoo Renewable Resources Board. Turn it over to you, Mr. Leeson.
Thank you, Chair. So for those who don't know me, I'm Nick Leeson. I'm legal counsel here for the Sawtoo Renewable Resources Board, or the SRRB. And I'd like just to commence by paying respect to and acknowledging that we're here today on the traditional territory of the L&I First Nation, who called this land home before the arrival of settlers and continue to do so. So I'm here to speak to both Bills 38 and 44. I will not be speaking to the Environmental Rights Act, and that's due to resource constraints, capacity constraints. From a funding perspective, the board's not able to provide comments on that piece of legislation at this time. But my comments tonight will be confined just to the process issues with respect to the development of these two pieces of legislation. And this is for a couple of reasons. One is because as we saw Tuesday night, there are limitations to be cognizant of in terms of time, and it's important that everybody that wants to use this forum has the ability to do so. But second, it's because my client is currently taking in all of the information through this process and the perspectives that have been put forward, and reviewing the bills further, because there wasn't enough time to review them because of some of the process issues that I'm going to speak to before they were introduced. Once we've gone through that process, I would like to confirm for the committee that, and put it on the record, that we will be providing written submissions at a forthcoming date in the near future. But lastly, the reason that my comments tonight are going to highlight the process issues is in order to make sure that it receives the spotlight that it deserves. We have a unique co-drafting legislative and policy development process here in the NWT. It's a process that the SRB applauds, supports, and is proud to be a partner of. In addition to my presence here tonight, you would have noted that there was staff support from SRB at the Inuvik session last week. This multiple venues participation in this committee process is indicative of the SRB's strong interest in being fully involved in this process from beginning to end. We intend to remain involved throughout every phase, and if given assent with the Assembly for these bills, we'll also hope to be involved in the regulation making and implementation phases that will follow that. Similarly, the board was an active participant in all the opportunities that were provided by the sponsoring department, ENR, to these pieces of legislation. The concern is that, as you've certainly heard, I'm sure, both tonight and Tuesday and throughout all the other sessions that you've conducted, is that the process used for the participation of co-managers like the board was inconsistent at best. As outlined in our joint letters that we submitted with both the Wacheze and Gwich'in Renewable Resource Boards of January 18th, these bills were largely developed in the board's absence until very late in the process. Bill 44, the Forest Act, was particularly upsetting in this respect. A full first draft wasn't provided to the boards until December 20th, or right before the Christmas break. It was then discussed with us in a solitary technical working group session held in January, and wasn't seen again by the boards until after it was tabled with the Assembly. This approach discounted dialogue with the boards and missed an opportunity for the building of consensus prior to its submission. As we noted in our joint submission of January 18th with the other boards, Bill 38's development, while not without its own process flaws, did at least include multiple iterations of a full draft of the bill for our review. And this was done prior to it being tabled with the Assembly. That process, allowing for that additional interaction, made a significant difference. And I think you've seen that difference through the comments you've heard from the submissions that others have put forward prior to that of the SRB. The reality is that the process applied to the development of Bill 44 left the SRB and the other boards with no other option but to oppose the submission of the bill at the time that it was introduced. A process that includes a one-time meeting on the substantive text, then not seeing the text again until after it's tabled, regardless of how many of the board's substantive suggestions for revisions were ultimately incorporated, is nonetheless unacceptable. Process is vitally important. And this is a point I want to focus on right now. You've noticed with the comments to Bill 38 how just a small difference in the process that was used in the creation of the bill can make a big impact on the total support that it receives. We would also submit that by adding that additional chance to review and work together, you receive additional positive dividends in that you bring to bear the subject matter expertise from around the territory to make sure that the bill is better and meets the needs of everyone around this territory. So we strongly believe co-development results in better laws, not just because it generates more buy-in, but also because it draws upon the expertise and knowledge of all of us. So I want to be clear on this point. While the content of both bills was greatly improved following the involvement and input that the boards, that the SRB specifically was able to provide, and the other boards, and we will not be opposing the assent of either of these bills in their present form, that's not to say that we don't believe that there is room for substantive improvement still, particularly with respect to the process that was applied in their development and process-oriented changes or amendments that can be made to these bills to improve the process going forward. The reason that process is so important to the board is because, as per the claim, the board has significant authorities over both protected areas and forestry management. These bills will affect the board's authorities and result in ENR officials and processes interacting with the board in those roles and responsibilities. A more inclusive approach to the co-drafting process was warranted in these circumstances, one that provided the resource boards with an opportunity to interact more fully with ENR throughout the process. While we fully understand the difficulties in incorporating the co-management system and the land claims into the legislative development process, particularly in a context where a large number of pieces of legislation are backloaded all to appear at the same time, which again speaks to the process issues where project management and orientation should have ensured that that didn't happen. So we understand the reasons that the process broke out the way that it did, but it doesn't mean that we're satisfied with it. What we really want to stress is that we need to take stock of the lessons that we learned from this process, the mistakes that were made, and commit to do better on it as we go forward. As a married man with 2 young children, I know how tempting it is in the mad dash of everything that we're doing, especially when you have 5, 6 legislative initiatives all going on at the same time, to get things done and push ahead and worry about process later. But I'm lucky that in my life I have a strong spouse who reminds me that it's true that how you do something, how you make the decisions that affect others is just as important as the decisions that you make and what it is that you decide. Because at the end of the day, process is a really big deal. It has a direct and meaningful impact on relationships. Our relationship as co-management partners here in the Northwest Territories means that relationships are enduring. They're not just transactional. Because of that, they have to be given priority. I point this out because we want to foster and support the co-management system working together because we know it works. We've seen it work. We saw this with the Wildlife Act. We know that we can do this, and we know that we can do it to get better results for the people of this territory and better laws. Well, the process and the development of these bills didn't meet the national example that I think that our co-management system provides for how reconciliation and working together can be achieved. Bill 44 in particular, in that respect, didn't meet that high standard. There does remain ways to improve the process going forward. For instance, and so these are a couple substantive changes that are amendments that we would recommend, and more will follow in our written submissions. But one would be to increase coordination with respect to implementation. So we recommend that a requirement to submit a report to the Legislative Assembly, akin to that that's found in Section 97 of Bill 38, be added to Bill 44. This also speaks to consistency in approach. Critically, we also recommend that the provision be modified to mirror an approach that's taken under the Wildlife Act at Section 15. And that ensures that the report that's required under the Wildlife Act is done in collaboration and input with Indigenous governments and renewable resource boards. We see no reason why this approach shouldn't be taken with both of these pieces of legislation. Similarly, we recommend a provision be added to the regulation-making authorities in both bills that provides that prior to the promulgation of any new regulation under the Act, the responsible minister will be required to notify Indigenous governments and renewable resource boards of the content that's being proposed, and then provide a limited time period in which they could make recommendations. We propose that these types of changes would make a significant difference, because conveniently, and the opportunity that we have here, is that even though the process that was followed in developing these 2 pieces of legislation didn't meet the high standards that we set for ourselves, the convenience is in that as with most pieces of legislation that are framework legislation like these two acts, the law that will give them life and that will animate them will come in the regulations themselves. This presents the opportunity for our involvement at that stage that was missed to have significant positive consequences and lead to a broader sweep of support from all of the partners in the co-drafting process. So the path that we recommend for the committee going forward is to include these or other similar process-oriented provisions that could be modified to the existing legislation or added to the existing legislation that's being proposed that require the ministry to collaborate with Indigenous governments and renewable resource boards, both at the stage prior to developing the regulations, as well as during the process of mandated reviews, audits, and reports before the Assembly. Essentially, focused amendments that serve to ensure the co-development process is respected, and that would ensure that the bringing forward of these bills marks the beginning of our involvement as co-management partners, not the end. Another positive of this proposal is a lot of these approaches that help to ensure that the co-management system is properly reflected already exists. The language is ready-made in the Wildlife Act. So I want to close by thanking the full committee, chair, and members for providing the opportunity for this additional audience. You didn't need to do that, and you went out your way. And just want to say it doesn't go without notice. So thanks again for listening and for leaving the room for the board to provide written submissions in the weeks that follow. Thank you.
All right. Thank you very much, Mr. Leeson, and thank you for providing your detailed comments, especially around process. As important as the legislation itself is, virtually every stop that we've made on this road trip, people have shared concern with us, but also, some thanks in some instances with regard to the processes. And so your detailed presentation today on process is very much appreciated, and it'll certainly be a critical piece in our recommendation and report as we go forward. So I have committee questions or clarifications. Start with Mr. O'Reilly.
Thanks, Mr. Chair, and thanks, Mr. Leeson, for coming this evening. You mentioned a January 18th letter. I don't think we have that. Can you just clarify whether that letter was sent to government departments or ministers? Yeah, we'll start with that. Thanks, Mr. Chair.
Mr. Leeson.
Thank you, Mr. O'Reilly. Yes, so it was CC to Mr. Michael Ball, but I can provide it to you after. I have copies with me, but at least I believe I do, so I can provide that. But
Yeah, if you can please resend those just for our certainty. And then one thing I did want to add too is that written submissions, not to put any strain on the situation, but our advertised deadline has been May 3rd at 5 p.m. And so if it's possible, if it shows up at May 4th, we're probably not going to file it in file 13, of course. So, but we would look forward to getting that as well. Further, Mr. O'Reilly.
Yeah, thanks, Mr. Chair. Just for those watching and that are here this evening, to be really clear, committee, although we may have seen way back months ago what's called a legislative proposal, like a very high-level sort of initial indication of what a bill might contain, we have not been provided any of the correspondence, any of the work of the technical working groups, any of the stakeholder advisory committee or group meeting notes. We've received nothing of that nature from the minister. We have asked for that. He promised to give it to us. We still don't have it. and which makes our job a lot more difficult. So that kind of correspondence would be very helpful for us. And I appreciate the fact that you've given us some feedback on the process, because we've heard similar sentiments from the communities and Indigenous governments boards that we've met with. And you've made some substantive comments to try to rectify that in the bills, and I think that's very helpful for us to hear. I'm hoping that in your written submissions, if you do have more substantive comments on how to better incorporate co-management into these bills, I think the Protected Areas Act is pretty close. The Forest Act is not even on the radar. If you have specific comments or suggestions about where co-management bodies wish to be inserted and at what stage, whether it's forest ecosystem management plan reviews, forestry agreement reviews, whatever, please let us know. That'll be helpful, and specific wording will be really helpful in terms of trying to ensure that we bring the bill to where it needs to be. And I'll just ask one more thing of you. In your comments and thinking about the process, we're sort of making history here, because we have a co-drafting process that is, based in constitutionally entrenched rights, and also in the devolution agreement through the Intergovernmental Council, and there's an act setting up the Intergovernmental Council. But the role of public government has not really been made clear. Like, what's the role of the standing committee in all of this system? Luckily, it's a bit of a backstop for you folks to come and talk to us about some of these things now. But if you can give some thought to that, or if you have any thoughts you want to share this evening about what the role is of, say, a standing committee in ensuring we have good legislation in the public interest moving forward, I would be very interested in hearing that. Thanks, Mr. Chair.
Thank you. To that, Mr. Leeson.
One piece to maybe add with respect to, so you've probably heard a lot of comments, I know a few were made on Tuesday, so I would imagine others have put this forward as well, which is a focus on the reg-making process that would follow, and ensuring that regulation-making process involves, co-drafting partners and other stakeholders from around the North. One piece would be that the federal government of Canada, of course, goes through a pre-publication gazetting process prior to the promulgation of any new regulations. That's not something that we incorporate here in the Northwest Territories, except for in instances where it is explicitly required under certain provisions in certain pieces of legislation, and that's largely legislation that we inherited through the devolution process from the federal government. But that kind of gives a starting point where to say that it can be done. And it doesn't necessarily need to be restricted to just Indigenous governments and institutes of public government. It can be expanded in scope to include the general public, include other regular MLAs. I'm certain that there could be accommodations made with that respect as well. And one piece to clarify on that is that while the land claims in several instances for certain subject matters require it, this type of provision, all it's doing is adding a notification. It's not in any way overriding or affecting or having any impact on the existing provisions that require that level of engagement through the land claim. So this would be an addition to that and a good safeguard to ensure that notification is provided to everyone so that everyone's involved.
Thank you, Mr. Leeson. Further, Mr. O'Reilly?
Thanks. Thanks, Mr. Chair. That's helpful. I'll push it a little bit more. Have you given any thought to what the role of the standing committee is and the relationship of public legislation making with co-drafting? And if you haven't put your mind to that and you want to think about it and submit something in writing, I think I would find that helpful. I think the committee would find that very helpful, because we're trying to figure this out as well. Thanks.
Thank you. And just for information, any sitting government, when they're going into their final year, formulates a special committee called a transition committee. And, you know, lessons learned is one of those things that we observe as well, and we're going to be obviously putting a number of recommendations with regard to process, et cetera, into the transition report so that the forthcoming government will have an understanding of some of the challenges and some of the recommendations that should be given consideration to. And so that's also one of the reasons why we're seeking input from stakeholders with regard to where they see the standing committee in the process. And so we're genuinely grateful for getting comments in that regard. So if you have any comment on that now, that would be fair, but if not, you can certainly send it with your written submission.
I won't go into any greater specificity on it than to state that, so right now, through a legislative review process that the Department of Justice within the government would undertake whenever new legislation comes forward, is that they will do an audit to ensure that it's in line with the scope of authorities that the jurisdictional authorities that they have. So look at Section 2, I believe it is, of the Northwest Territories Act to ensure that the legislation isn't ultra vires. So that's part of the process. So that piece, without breaking too much new ground, that could theoretically be expanded to include additional process-oriented items, such as were these new regulations provided to standing committees, or were they provided to MLAs at large? And those types of things could certainly be added because, and it wouldn't in any way be doing things. It would be breaking new ground in the sense that it's not necessarily that inclusive, isn't done anywhere else, but inclusivity is something that we believe in strongly in the North, and it's built throughout the co-management process, so I think it coordinates well with that.
All right. Thank you. Nothing further, Mr. O'Reilly? Anything further, Mr. Testart?
Thank you, Mr. Chair. Well, process is something I'm passionate about, so it's very helpful to have these comments. I think I have learned more about how the co-drafting system works, how the Intergovernmental Council works in the last 2 weeks than I have in 3 years. And that's not for lack of trying. Multiple times this committee and other committees have tried to see what that work looks like, tried to be involved so we wouldn't be in this position where we're playing catch up. And we haven't been allowed through that door. And I think that's another thing we have to consider as well. But what strikes me is that there were two other pieces of legislation, the Waters Act and the Environmental Protection Act, that were supposed to be done with this package of bills and have been put off to a future government. And that is, as we learned through these hearings, a result of the parties being too far apart. So when I look at this bill, and I recognize that there's a sense that, we've seen how legislation works in the House. Rarely is it defeated, so most likely it will proceed. And amendments to the bill is probably the best shot we get. But ideally, the sense I'm getting from our consultations is that all bills need to be co-drafted to the satisfaction of all partners. Is that your understanding of the formal and informal relationship that's in place, at least from the board's perspective, with the government of the Northwest Territories on the co-drafting process? Is there a requirement that there is at least consent or a consensual sense that this is good legislation that works for all parties? Thank you.
Thank you. Mr. Leeson?
It's an established process now that governments engage on all legislative developments that they undertake publicly. Public engagement is not something that, now it seems as though it's obviously something that needs to be done. It's a foregone conclusion that it'll have to occur, but that wasn't necessarily the case 15 years ago even, so not that long ago. So it wasn't necessarily just because the legal provisions in an existing authority mandated that it be done. It was done because it was best practice and is what should happen. And so I guess my response to that would be that certainly with respect to parties such as Indigenous governments and certainly the Renewable Resources Boards where they have demarcated authorities under an existing claim, they need to be, if there's any subject matter, specifically with lands and resources and waters oriented legislation, they need to be directly solicited for if the level of involvement or participation that they wish to engage in at the front end, and then have the opportunity to participate, and in a meaningful way, and not just a check the box exercise because it's mandated. And that's the nice thing about, I think what your question is getting at, Mr. Testart, is that if it becomes best practice, so it's not necessarily grounded just in, well, this is a legislative requirement, so we're doing it because we have to, but you're doing it because it's the right thing to do, it's the way we do things in the North, you're going to more likely than not have a process that isn't about checking boxes, but that is about substantive and meaningful engagement.
Thank you. Further, Mr. Testart?
Thank you, Mr. Chair, and thank you, Mr. Leeson. Just briefly, we've seen a lot of, we've seen quite a number of bills, not so much all at the same time over our term in the Assembly, but I have never seen the degree of public concern around bills until this process started. Cannabis had more public support than Bill 44, and that was a controversial issue that affected people in a very personal way. So I'm not taking the concerns that you have raised and the SRRB have raised tonight, or the other Indigenous governments, and I think if we're going to live up to our the principles of reconciliation that this government is set out to achieve, then we need to be doing things correctly. And I'll just leave it at that, but I'm taking this very seriously. Thank you.
All right. Comment noted. Anything further from committee? If there's nothing further, Mr. Leeson, I want to thank you again for coming and presenting on behalf of Sawtooth Renewable Resources Board, and we look forward to receiving your written submissions as well.
I do appreciate a little bit of grace on that if you can. So thank you, Master Joe.
Okay. Thank you. Next I have Matilda Becker. Come on up. Ms. Becker, we'll turn the microphone over to you.
Thank you, Mr. Chair. Firstly, I'm going to apologise for reading off a sheet because I will otherwise not be able to keep up with my thoughts. So, thank you for this opportunity to present my thoughts on Bill 39 of the Environmental Rights Act. My name is Matilda Becker. I'm a PhD student from the University of Oxford in the UK. I've been in Yellowknife since September 2018, carrying out fieldwork, which has mainly involved speaking with geologists about the philosophy behind geological mapping. That is to say that the Environmental Rights Act is not related to my research. I am not presenting on behalf of a specific organisation, but would like to provide feedback on Bill 39 within a broader context of public democracy and environmental rights. I will also speak to some specifics of the bill. I am motivated to provide comment on the bill since it is a unique and progressive piece of legislation within the Canadian jurisdictional context. I believe politics and change is led by example, as since the Northwest Territories are one of the few jurisdictions in Canada to have an Environmental Rights Act, it is imperative that the best possible example is shown here for others to follow suit. I hope this presentation should take me less than 15 minutes. In this presentation, I give some comments on 1. The procedural aspect of drafting the bill, 2. The need to identify the rights of residents to a healthy environment, 3. The need to define what healthy environment, significant harm, and reasonable grounds for concern mean, 4. That such definitions are important in ensuring human health, and 5. The need for informational access for the public via a registry. My underlying message is that the Environmental Rights Act is not primarily about environmental protection, but about protecting residents' right to a healthy environment. The difference is significant, and ensuring that the sentiment will be clear throughout the Act is imperative for it to be meaningful, robust, and effective. So, procedural notes. I would firstly like to thank the hard work of the Standing Committee in hearing and responding to the public's comments on these many pieces of legislation. Your work over these weeks is no enviable task. This format of legislative review and deliberative democracy is a model that should be praised. I hope it can work to inspire other jurisdictions globally, as transparent and inclusive governance is critical in fostering an environment of political trust and accountability. The work of concerned residents in engaging with this process has, however, been made much the harder by the sometimes piecemeal, mistimed and fragmented nature of information sharing, especially in relation to what we heard documents and plain language summaries. It would also be helpful if government departments could provide the evidence of their best practice reviews and how these have been incorporated into the bills. Furthermore, I would challenge the ability for organisations and publics to deliver comments on the drafting of public bills without being named. Surely it is in the public interest to know who is informing the Territory's legislative development. Such openness would help Cabinet reach its mandate for transparent governance. I will now address some specific recommendations for changes and additions to the bill, which I believe will help ensure the right to a healthy environment is protected. As it stands, the ERA is a bucket with holes in, and the Standing Committee has many opportunities to help plug those gaps. The largest hole in the ERA is the looseness of terminology and the lack of critical definitions. There are two critical definitions that must be included: that of the right to a healthy environment and what a healthy environment actually means. So, first, I ask the Standing Committee to ask the Cabinet to include the right to a healthy environment as a standalone definition in Section 1 of the bill to help ensure that environmental rights are not only retroactively enforceable. This is a fundamental component of environmental acts found globally. Canada is one of only 12 in 192 countries in the United Nations not to recognise this right constitutionally. As a standard bearer of environmental legislation in the country, the Northwest Territories therefore have a key opportunity to lead by example and mirror contemporary legal trends. As examples, India, Bolivia, some US states and New Zealand all consider environmental rights as a fundamental pathway for ensuring socio-cultural and economic health. May I suggest the Stockholm Declaration of 1972 as a starting point for those amending this Act to write an appropriate definition. Other presenters, like Linda Collins, have provided other potential definitions in writing, but the Stockholm Declaration reads that man has the fundamental right to freedom, equality, and adequate conditions of life in an environment of equality that permits a life of dignity and well-being, and he bears a solemn responsibility to improve the environment for present and future generations. Note that these sentiments on environmental rights have been poorly reflected by the bill. There is no substantive link made between a healthy environment and human well-being, and only cursory attention has been paid to intergenerational environmental rights in the preamble. I'll return to these in a moment. Thus, without the standalone definition of residents' right to a healthy environment in Section 1 of the bill, my concern is that residents must wait until significant environmental harm has occurred or is about to occur before they may assert their right to or have them recognised. This leads me to my third key point: the need for definition of key terms healthy environment, significant impact, and reasonable. Without these, residents, organisations and governments' perception of harm will remain entirely subjective. This cannot be allowed if consistent and predictable application of this Act is to be ensured. The Act must contain substantive definitions of, at a minimum, a healthy environment. This would provide a legal baseline against which significant harm could be judged, whilst adding clarity and assurance to any individuals or organisations engaging in activity that could cause environmental harm. This is a fundamental rule of law. It must be clear and predictable. Similarly, if a definition of reasonable grounds cannot be reached, having healthy environment defined would add a point of relativism for residents to judge if their cause for concern may be valid, and indeed any minister or court investigating. I am not a lawyer by training, so cannot speak to the exact wording that these definitions should include, but a definition of healthy environment must be included at minimum to ensure the bill's strength and enable it to be understood and effectively implemented. Fourthly, the importance of definitions in ensuring equal access and application of the law and avoiding the exacerbation of existing inequalities. A healthy environment must be recognised as a baseline for a healthy society. Therefore, a standalone recognition of the right to a healthy environment must help may help ensure that distributional injustices do not emerge or become reinforced amongst the population as a result of weakly enforced or imbalanced access to the legislation. If that right is not defined, it relies upon the action of the individual to assert their right, which they may not be in a position to do. Consider, for example, non-adults or perhaps severely disabled people. There is significant evidence to demonstrate that environmental harms are often differentially distributed between populations, and that the impact of environmental ills cannot be met with the same resilience by all demographics. Additionally, environmental injustices may exacerbate socio-economic problems in already vulnerable populations. Peer-reviewed research from around the world makes strong links between A, socio-economically deprived people being more likely to live in proximity to an environmental hazard, and B, the spatial relationship negatively impacting the physical and mental health of those exposed populations. This evidence demonstrates that strong environmental rights are important not just for the preservation of environmental health, but for reducing social stresses on populations which inevitably have economic consequences. I must reiterate that this bill should not be thought of as a means to protect the environment, but as creating a solid foundation of societal well-being which has its foundations on a healthy environment. Therefore, a point of concern lies in Section 8, investigations, which ensures that only those with access to a commissioner to swear an oath may make an appeal for investigation. May I suggest that this requirement is removed in order to enable those living remotely to access their rights easily without disproportionate inconvenience or cost to them. Perhaps a return to the previous Environmental Rights Act requirement for 2 adults would be preferable. The Act must also account for the diversity of the NWT's residents and communities, and at current it does not do so. After all, can Cabinet ensure that a Commissioner of Oath should be available even in most remote communities? Furthermore, the overbearing ability of the Minister to use his or her discretion, a very concerning pattern amongst the new bills, to decide whether or not to proceed with an investigation undermines the Act's ability to stand independently of politics. May I suggest the inclusion of a subsection under Section 8, investigations, that at least allows for the appeal of ministerial decisions. Another point of concern is intergenerationality. Whilst it is recognised as important in the preamble of the bill, certain elements of the bill undermine it. For example, Section 13, subsection 4 reads, "It is a complete defence to an action commenced under subsection 1 that the harm caused by a defendant's act or omission is and will remain entirely restricted to lands owned by the defendant or to lands in respect of which the owner has expressly authorised the defendant to cause the harm." Authorisation should not be allowed as a complete defence. This allows for intergenerational challenges of dealing with predecessors' environmental harms to continue, and it is disappointingly short-sighted. I will now turn to my final point, and that is the need for informational access by the public through a registry. I note how, despite assurances from ENR in their consultation for this bill, there is to be no public registry. The Aarhus Convention, which I am fully aware Canada is not a signatory of, demonstrates the recognised link between public access to information and the public's right to a healthy environment. I quote, "In order to contribute to the protection of the right of every person of present and future generations to live in an environment adequate to his or her health and well-being, each party shall guarantee the rights of access to information, public participation in decision-making, and access to justice in environmental matters." As well as speaking to my previous concerns about access to justice, the Aarhus Convention highlights the importance of informational access and public participation as a component in protecting environmental rights. It is not enough to legislate for environmental rights and to make investigations possible. The inclusion of the public must go beyond investigation as a final stage in rights protection. The public must have a portal through which to know about decisions made by government relating to the Environmental Rights Act, and should be able to post comment on any new policies or legislation that might impact that right. Ontario has such a portal, the Environmental Registry of Ontario, which Cabinet and ENR could look at for best practice. In this registry, people are able to comment on changes to legislation, any proposed or ongoing consultations, and to view government decisions. So, to close my presentation, I'd like to thank you all for giving me your time and also for your work ensuring that the NWT's residents have the opportunity to express their opinions on this legislative development. Thank you.
Thank you. Thank you very much, Ms. Becker. I have to say that as a member of the public at large, that's a very good, substantive and detailed submission, and admirable and commendable on your part. And so I don't know why all the members of the public can't make submissions like that, right?
A matter of time, probably.
So, I'll turn it over to committee for questions or any points of clarification. Mr. O'Reilly.
Thanks, Mr. Chair, and thanks, Ms. Becker, for your presentation. In here, you noted that there's some broad sweeping ministerial discretion, which seems to be a pattern through many of the bills that we are looking at. You've recommended that there be an appeal process if the minister decides to not pursue a request for an investigation. And I'm just wondering whether you've given any thought to where the appeal would go. Is it just to the court system, or somebody like the recently established Ombud here, or someone or some other system? If you've given any thought to that. Thanks, Mr. Chair.
Thank you, Mr. O'Reilly. Ms. Becker.
Thank you, Mr. Chair and Mr. O'Reilly. I had given it some thought, but not knowing how such appeals might work in other legislation, I don't actually have an answer to that. And perhaps there is some other process that is similar that can be used as a point of comparison on which to model this that is effective.
Thank you. Further, Mr. O'Reilly.
Thanks. Yeah, I appreciate that, and it's something that I'm sure we will look into, different options. I think one other accountability mechanism, and there is provision in the bill, I think, for this, where the minister decides not to pursue an investigation. I think it's 9 subsection 6. It says that the minister shall give notice of the decision together with a brief statement of the reasons for the decision. I think one of the other ways to establish some accountability here is not just a brief statement of the reasons, but actually written reasons. I don't know whether you have any other thoughts about how to circumscribe ministerial authority here, or how to provide for greater transparency. Thanks, Mr. Chair.
Thank you. Ms. Becker.
Thanks again. I don't have any further suggestions, but I feel as if Section 9, subsection 6 would work well if it were posted on a public registry that people could actually see those.
Thank you. Anything further, Mr. O'Reilly?
Thanks. Just one other one, if I can. I'm glad that you've raised this issue of the promise of an all-encompassing environmental public registry during the consultations, or at least to look at it, and the bill certainly doesn't reflect that. So we're left with a bit of a hodgepodge that we're looking at now. There's a public registry in Bill 38. It's not clear what's to go on it, quite frankly, but that's for the Protected Areas Act. There's no public registry in the Forest Act, even though the minister and ENR staff can exercise a lot of discretion over forest ecosystem management plans, forestry agreements, licenses and permits. Where is that to be found? So I'm wondering if you have any comment about the pros and cons of having a central environmental public registry versus a scattergun approach that we're seeing across a number of different bills, and I think even some of the other bills that we're going to look at in the next round have some issues about public registry as well. Thanks, Mr. Chair.
Thank you. Ms. Becker?
Thanks. I think ideally it would be great to have everything done through a central point, particularly as it's a single department who would be responsible for that registry. It makes sense to, and it might be more economical to have it all done in one place. Yeah.
Right, thank you. Next I have Mr. Testart.
Thank you, Mr. Chair. Thank you very much, Ms. Becker, for your presentation. I had not, even though it's called the Environmental Rights Act, it's easy to think of it as environmental protection, and I think you've given me a lot to think about in terms of this being a rights-based exercise and not an environmental exercise. I had questions around the registry component. Now, you mentioned the Ontario website. I plan to review that later, but could you give us more kind of what's the user experience of using Ontario's version, and how do you feel that that's a superior tool for public engagement than what currently exists in the NWT? Thank you, Mr. Chair.
Thank you. Ms. Becker?
Thanks for the question. I think it is actually very user-friendly. It's well categorized in terms of what is upcoming and what is a decision that has been made, or so it's quite easy to follow where things are in terms of their sort of stage through the decision-making process, and I think that's really helpful because that can often be quite confusing here. It's quite easy to get a broad overview of a lot of things happening. So if you're wanting to, I don't know, look for some water license for a mine, you can get that there. But you can also see changes to perhaps the Carbon Tax Act alongside that. So it's a lot more comprehensive, and I think that's good, and also in sort of broadening people's scope of vision and sort of seeing what is actually included in participating in commenting about what in the environment. So I perhaps that's also their model of doing it is a way to increase participation, because you open the scope for people to see what they can comment on rather than putting it in lots of different channels.
It's sort of a one-stop shop registry.
Yeah.
Further, Mr. Testart?
That sounds familiar to similar positions that many of us have taken over the years, and many of your submissions were actually discussion points we've been having as a committee. So it's good to know that more people are thinking about that than just some MLAs. You mentioned many nations that have declared out the right to healthy environment, a fundamental right of their citizens, by defining it through the legislation, through this act in particular, and rather than a broader rights piece like the Human Rights Act. It's more or less narrowly defining what you can do with that right amongst those terms, rather than something that's defined in the Human Rights Act that has, just a blanket prohibition and the Commission will have to deal with it. Do you think that this approach, or in your knowledge of how other governments have handled this, is it kind of a narrowly defined right, the way it's being contemplated in Bill 39, or is it a broader right that would be part of a human rights code or Bill of Rights? Thank you.
Thank you. Ms. Becker?
Thanks. I think the issue here is that it's not defined. The right to have a healthy environment is not defined. Therefore, whether you apply it in narrow or broad scope is kind of superfluous to that. But it seems to be that the definition would support people's ability to assert their right to investigate. At the moment, it's a right to investigate, but the question is, investigate what? So, in terms of comparison with the detail of other legislation, I'm not sure.
Thank you. Further, Mr. Testart?
Yeah, no, thank you for that. You're quite right. It's not actually in the Act, but I think you've given us some helpful suggestions of how to make this a proper piece of rights-based legislation rather than what it currently is, which is how to define an investigation. And it should be noted that this began as a private member's bill. It was not a public bill when it first came into law, so it's kind of been an oddity. And the fact that the government's picked this up and made it part of their devolution legislation, I think speaks well to the intentions of public government in the Northwest Territories. I think there'll be an opportunity to improve it, and hopefully we can make this a truly world-class piece of rights legislation for our citizens. So thank you very much for providing your thoughtful feedback. I'm not sure if the chair asked, but if you could provide your speaking notes in writing, that would be helpful for us moving forward. Thank you. Oh, do we? Oh, thank you.
Thank you, Mr. Testart. Anything further from committee? If there's nothing further from committee, then thank you again, Ms. Becker, for your presentation. Very much appreciated. Next I have Zoe Guile with CPAWS.
Yeah, and
come on up.
Brecky.
Yeah. You both of you are welcome to come on up. And I'll turn the microphone over to you, Ms. Guile.
Thank you. So, as you mentioned, I am here with the Canadian Parks and Wilderness Society Northwest Territories chapter, and I'd like to thank the committee for this opportunity to speak on the NWT Protected Areas Act. So, CPAWS NWT strongly supports that the Protected Areas Act be passed in the spring session of this 18th Legislative Assembly. The Protected Areas Act is a necessary piece of legislation that will allow the GNWT to meet its responsibility of protecting, conserving, and maintaining biodiversity and cultural continuity in the territory. Protected areas are a core component of good land management. They contribute to the land use certainty, stimulate economic diversification, and give future generations a greater chance to benefit from the water, fish, plants, and wildlife that provide for many people in the NWT today. Protected areas buffer the impacts of climate change by storing carbon and can provide connections across landscapes that allow plants and animals to move and adapt in response to a changing climate. Prior to devolution, the GNWT requested time to develop a northern tool for the establishment of protected areas. This followed 15 years of commitment and a substantial investment from government, communities, and organizations to advance the candidate areas that are on the map today. Much hard work has continued in the interim. We are excited that the Litzel Dene First Nation has forged ahead with Thaidene Nene and are ready to formally complete establishment. The Kasho-Otine government continues progress for their area, the Ramparts River and wetlands, and the Clecho continue work on Denaga, Wekwahodi along the north arm of Great Slave Lake. The Protected Areas Act will enable the GNWT to promptly support outcomes for these areas and achieve some of its own conservation responsibilities. It is also important to consider the opportunity that now exists through the Government of Canada Nature Fund. This is a source of new money that is available to the GNWT and Indigenous governments for supporting land protection. All of the current candidate areas mentioned before are eligible for this fund. Conserving land and water for people and for nature should be a priority that is aggressively pursued, and for that to occur, the timely establishment of these protected areas is necessary. For this reason, we are grateful for the progress that has brought us here today. We have reviewed the Protected Areas Act with national and international protected area standards in mind, while also considering the unique requirements for legislation in a Northwest Territories context. Tonight, I'll provide a few overarching comments, and we will also submit written recommendations that capture some of the finer points and details. The preamble of the Protected Areas Act sets a good tone. We appreciate that most of the important principles from the preamble are included within sections of the Act. However, the Act would be strengthened if the benefit of future generations and also climate change considerations were included in one of the sections, making them enforceable under the Act. The benefit of future generations is integral to the purpose of a protected area. References to this can be found in other similar legislation, such as the Canada National Parks Act, and inclusion could occur in the purpose section. Climate change considerations could fit under Section 24C, Management Plans, as an objective of baseline data collection. CPAWS NWT acknowledges the work invested by ENR and the Indigenous Technical Working Group to build an act that encompasses important principles for the persistence of healthy ecosystems in the North. The Act is progressive in its inclusion of an establishment agreement section requiring the opportunity for Indigenous governments to enter into a nation-to-nation agreement structure with the GNWT. We are aware that this section of the Protected Areas Act has earned notice and positive acknowledgement from other jurisdictions in Canada. We do have concern generally where delegated authority for regulation making is given solely to ministerial authority. However, shared decision-making through an establishment agreement improves certainty that a protected area will be maintained permanently for future generations. The inclusion of civil engagement is also important for this same reason. There are several sections within the Draft Act where the minister is required to ensure an opportunity for public engagement, as well as the creation of a public registry. This is good practice, and we appreciate that we will be invited to participate in the future. However, Section 36, with regards to transportation and transmission corridors, could be improved by incorporating transparency and must include participation. Providing a right-of-way for transmission or transportation corridors would likely create new access into a protected area and does change its boundaries. We request that Section 36 include a requirement for minister to provide an opportunity for public engagement and for written reasons for ministers' decisions to be posted to this registry. And that's the end of my comments for tonight. And to wrap up this oral submission, I'd like to reiterate that while we are recommending some improvements to Bill 38, CPAWS NWT supports having the Protected Areas Act passed during the spring session of this Legislative Assembly. And thank you for your time.
Thank you, Ms. Guile. Mr. McCracken?
Here to help with any questions.
Okay, appreciate that. All right, I'll turn it over to committee for any. Mr. O'Reilly.
Thanks for coming back this evening and for the presentation. I look forward to the written version because you sped through a bunch of things there for us. But I guess I want to pick up on the public registry issue. You mentioned that you'd like to see written reasons, say, for the Section 36 transmission transportation corridors through an established protected area. You'd like to see that put on the public registry. Are there other things that you think should be on the public registry? And if you can't think of a bunch of them off the top of your head now, I would really appreciate you giving some thought to that in your written submission. And the other reason why I'm raising this is we have a written submission now from the Chamber of Mines, and they've actually asked for the same thing. They want a detailed, inclusive, transparent public registry. So I find it interesting that conservation NGOs are asking for this in the Chamber of Mines. So anyways, any other thoughts about other steps or documents or things that should go on the public registry that you could share with us now? Thanks, Mr. Chair.
Thank you, Mr. O'Reilly. Ms. Guile?
I'd like to comment to that.
Mr. Breaking, and just for your information, you don't have to touch the microphone. You'll just go through me.
Oh, okay. Thank you.
Yeah. And is it pronounced Brecky?
Brecky, yeah.
Brecky, all right.
My understanding is the public registry will be informed primarily by the contents of the establishment agreements, beginning with meets and bounds, details thereof. Our comments on Section 36 simply address the requirement that when such a decision is made where a protected area has been established, there should be a reason for decision. And one other note on that is also alternative means for that type of development. Perhaps onerous to have a detailed list in this case, considering the nature of what an establishment agreement might bring. There is a list of things that could be in an establishment agreement within the legislation. I hate to use the word assumption, but I believe this is where that list per se, as it comes into an establishment agreement that's applicable to the area it's being established, would be written into the registry, including, I hope, reasons for decisions.
Okay.
Yeah.
Thank you. Further, Mr. O'Reilly.
Thanks, Mr. Chair. And, I appreciate the importance of the establishment agreements. I guess my difficulty is that they're going to be basically negotiated between a minister and his or her staff and Indigenous governments. So there may not even be a role for the public in seeing or understanding what's in the establishment agreements. I'll stop there on that. But So I'll just give you some examples of things I think might go on a public registry. There's to be consultation when a candidate area, or I shouldn't say consultation, notice given to land use planning boards, renewable resources boards when a candidate area is identified, presumably with some expectation or anticipation that they may actually respond about maybe conformity with a land use plan, or whether, let's say, renewable resources board, whether they think it's a good reason to establish a protected area. That sort of correspondence I would expect to find on a public registry or be able to see it there. What about when park management plan, when it's developed, why wouldn't that go on a public registry? Or if a minister decides to delist a protected area, they have to give reasons. Why wouldn't the reasons go onto a public registry? Anyways, I guess I'm trying to make the point that establishment agreements are important, but they're not necessarily even a public document in here. The establishment agreements themselves might not go on a public registry. So I just want you guys to give some thought to what sort of things you think should go on the public registry to ensure sound public participation in a process and consistent with open government policy that this cabinet has put forward. Thanks.
Thank you, Mr. O'Reilly. Anyone care to comment to that? Mr. Brecky?
Beginning with a nomination would also be where it would start. And as I said, I might be a little remiss to try to provide a list on the fly here, but as the process goes forward, I believe that would be the registry. As far as an establishment agreement, I might not expect either to see the details of that as it's being hashed out, but I mean, there's some trust left to that.
All right. Thank you. Anything further?
No, thanks, Mr. Chair.
If there's nothing further from committee, I want to thank you both for presenting on behalf of CPOS. And we look forward to also receiving your written submission. Thank you. Thanks again. Next we have Lois Little from the NWT chapter of the Council of Canadians.
Well, thanks very much for having this second session. It's much appreciated. I didn't sign up the other night because I didn't think the Council of Canadians perhaps had anything to add to all the presentations that have been made, but I think that there are some things that we need to highlight. We did make a written submission, and so I guess I'll highlight some of those comments that we made in our written submission, and some general things I think about process as well that are not in our submission. We've had an occasion in the past to use the Environmental Rights Act, and we've been pretty active in the stakeholder consultations. It's been really interesting for us to see where things have gone from the consultations that we were participating in to the draft that was put out to the public. And I think we're generally aware that Indigenous nations or Indigenous governments have not really weighed in that much on this Bill 39, mainly because it's more individual rights focused rather than collective rights focused. I think whenever we talk about things changing in the drafting process, I'm not sure that this act really went through that co-drafting process. So it's curious for us to see what fell on the cutting room floor from the consultations and the stakeholder discussions to what actually emerged in draft Bill 39. We haven't made any comments on the other bills because I think that there's there's commonalities that need to be considered across the acts, and, you know, as a volunteer organization, we don't have the capacity to do that. So we're going to, we've just kept our comments to Bill 39. I think we're of the opinion that this draft that was put out is really just a starting point. There's really so much work that needs to be done, and I think you've heard from presenters on Tuesday night and again this evening that there's a lot of work to be done on the Environmental Rights Act. There's a lot of progress that has been made from the current Environmental Rights Act. You know, we really like the fact that the scope has been broadened. There's a bit of an attempt to make this rights-based. There's a bit of an attempt to take an ecosystems approach to reporting. You know, like there's baby steps that have been made, but I think, as Professor Linda Collins contended in her paper, of which the Council of Canadians signed on to in support, you know, there's really a lot of work that needs to be done. We have a bit of an issue with the preamble. It's a rambling, unfocused kind of piece that sets out the intent of this act, and it really does need to be tightened up and much more specific. And we're going to be looking for a stronger preamble that actually is a statement of principles that underlie this legislation. We have the Council of Canadians nationally and here in the NWT have long advocated for the inclusion of the United Nations Declaration on the Rights of Indigenous People and all the other universal declarations and conventions that the Legislative Assembly has signed on to, that these covenants or conventions be reflected in law. We have pressed the Premier on why this omission occurs in this post-devolution legislation in an age of reconciliation, in a time when the TRC's 94 calls to actions all have, well, essentially all have UNDRIP as integral to those calls to action, and we're not naming that legislation in our work here when the Legislative Assembly has committed to implementing the calls for action. So we're looking for a set of principles that really are reflective of where we are at this time in the 21st century, at this time in the Northwest Territories, where we're looking to come together as different orders of government to really support and protect the right to a healthy environment. And I think we're looking beyond just the right to actually a stronger statement of purpose that includes our shared responsibility for stewardship to northern ecosystems. So the purposes statement in the draft Bill 39 is an extremely weak statement, and we're recommending that be strengthened, and that we give paramountcy to the right to a healthy environment. We were concerned about the minister's delegation or power to delegate in Section 7 of the draft. It's pretty difficult to see where the accountability and the transparencies are in that clause. So we're looking to have any decision that the minister makes around the delegation of powers, that a rationale for that decision to delegate be given to the Legislative Assembly, and the public be made aware of why the minister is delegating that power and to who. We've had experience. The Council of Canadians applied for an investigation under the current Environmental Rights Act. Our application was denied. We did not have a rigorous or a robust explanation of the denial of that request. And we're not seeing in this draft any real effort to explain to the public as to why a request for an investigation would be denied. And it's troubling, actually, the wording in this draft, that, you know, a request could be denied as being deemed frivolous, you know, or not serious enough. Like those are really, that's really a concern, that wording, because it's so subjective. We're concerned also about the timing that's laid out in this act. You know, it's 90 days for everything. And we would expect that a more timely response to a public request for an investigation. And a more timely response would be 30 days, in our opinion. There's no provision in this draft for any investigation in an emergency situation. We live in an age of climate change, some would say climate breakdown, and the potential for natural disasters increases, and governments are not everywhere. We don't have people on the ground monitoring things, and so we're relying on the public a great deal to be able to look out for our environment. So we're looking for some kind of provision in this legislation that recognizes the need to respond to an investigation in an emergency situation, and that response be fast-tracked. The legislation limits the liability of GNWT and employees acting in good faith. That's all quite reasonable. But in our experience, even when people act in good faith, there can be negligence. And so I think there needs to be some kind of provision in this act that recognizes that. It's wonderful that we've got whistleblower-like protection in this act. Like this is really encouraging. But I guess we worry that we live in times where our world is changing, our climate is changing, our environments are changing, our ecosystems are breaking down, and in the time that I have worked throughout the NWT, I've always heard from the communities that they're coming for our water. And at some point, probably not in my lifetime, but hopefully not in my lifetime, there are going to be water wars. There are going to be battles over diminishing resources. And we're seeing elsewhere in the world, elsewhere in the country, actually, where there is state violence against individuals who are water protectors or land defenders. I think we need to give some attention to some protections for those individuals who are not employees of government. We need to consider how we can protect the rights of those people who are defending the water, protecting the water, defending the land. And that's a tough one. The United Nations is struggling with it, but they are dealing with it or trying to deal with it. And I think as you folks who are interested in having world-class legislation here, I think that that's an issue that we need to wrap our heads around. There's an interesting section in this draft legislation around a statement of environmental values. It's a good thought. It's on the right track, in our opinion, but there's nothing in this legislation that is binding government agencies to actually protect the right to a healthy environment or the health of our ecosystems. And that, in our opinion, is an omission in this act. We all need to be on board, and whether you're working in infrastructure or health and social services or whatever you're doing, all public agencies should be bound to protect those rights. As I said, it's great to see this state of environment reporting, and it's great that climate change is one of those factors that is included in the state of environment reporting. Because our world is so dynamic, changing so much, we're recommending that there be regular reviews of state of environment reporting so that we are indeed reporting on those things that are meaning and relevant, to you folks as legislators as well as us citizens. So as I was saying, the Council of Canadians was very active in the stakeholder consultations leading up to this draft. And we were just really excited about this legislation because it was so hopeful. And, I think as Mr. Testart was saying, rights-based is where we really were thinking about we were going. So we were quite surprised that there were a couple of omissions in this draft, aside from the things that I've mentioned. No public registry, which was strongly advocated in the discussions that we were part of, and protection of the rights of nature, which were strongly supported in the consultations that we were part of. And so, as I said at the outset, kind of a bit surprised about what got left out and why it got left out, because as we understood, there was not a lot of, or not a lot, I'm not sure which, involvement of Indigenous governments in the drafting of this legislation because it's individual rather than collective rights based. Could be wrong on that, but so I don't know why the registry got lost. I don't know why the rights of nature got lost. So we're recommending that those two elements be revisited and brought back into an amended Bill C-39. So, yeah, maybe I'll just leave it at that, and then we can have a chat about anything that you want to chat about. Good, thank you.
Thank you, Ms. Little. I appreciate your comments and suggestions and presenting on behalf of the Council of Canadians, the NWT chapter. You did touch on a few things that we have been hearing from others that are a little bit even outside of this act. We've been hearing a lot about waters and water protections and transboundary issues, and so as we know, the Waters Act is not coming forth in the life of this Assembly, but will certainly be a priority, I suspect, of the forthcoming Assembly, as well as the Environmental Protection Act. Climate change is a connection that a lot of people from the public, including Indigenous governments, have connected to a number of these bills that we're reviewing, and so we're grateful for the commentary on that as well. I'll turn it over to committee for comments or questions. Mr. Testart.
Thank you, Mr. Chair, and thank you, Ms. Little. You mentioned concerns around the preamble. The two bills we're going to be looking at on the next round of consultations were drafted by the Ministry of Industry, Tourism, and Investment, and they did not choose to do a preamble. Instead, they have a purpose clause in the Mineral Resources Act, which lays out as a clause of the bill what the bill should be, and what that means is when a court would be interpreting that, they can go back to those clear principles in understanding what the bill should do. It's a different approach than a preamble, and one I haven't seen before. Do you think something like that, to replace the preamble, would address your concerns? Thank you.
Thank you. Ms. Little.
Yeah, thank you for that. Yes, actually, that as we understand legislation, that is the value of those statements of principles and for legal interpretation. And as this draft is laid out right now, like it's very weak and it's rambling all over the place. And I think we've offered some examples in our written submission of the kinds of principles that should underlie this act. And I believe that Professor Collins offered some in that presentation as well. And that's exactly, as I understand, what the courts do look for in interpretation, and especially in rights-based legislation. That would really strengthen this act.
Thank you. Further, Mr. Testart.
Thank you. You mentioned investigations in an emergence situation. Can you explain what kind of situation you're contemplating that would warrant an investigation, and specifically what kind of timelines you're looking at? Thank you.
Thank you. Ms. Little.
Yeah, we're seeing right now in southern Canada, we're seeing with the flooding, for example, in Ontario, we're seeing sewage leaking into water bodies. We're seeing toxic chemicals leaking into water bodies. And that's an emergency situation. And there are not enough public enforcement people or public servants on the ground monitoring all of this stuff because it's chaos, right? So I guess that's an example for me as to where there might be an emergency situation where, Joe Schmo is in a community and seeing this kind of stuff happening and wondering what's going on and what kind of impact this is having on his or her rights to a healthy environment.
Thank you. Further, Mr. Testart.
Yeah, thank you. I think that's somehow how the Act currently works, right? You notice something, a concern like a smokestack, billowing smog, and then you start an investigation. So I think if we were going to add an emergent clause, there'd have to be, some precise specificity around that. So perhaps you could think more of, very clear language around it if you're to provide that recommendation to the committee. But moving to my last question, I too think the state of the environment reporting is a bit long-ranging compared to the reality we live in. It's May and it was snowing 2 days ago. There's rapid climate change that's occurring that we can see, just any citizen can see. And I think that a State of the Environment report can be a tool for public government in the Northwest Territories. What kind of reporting schedule do you see as being superior to the current proposed 4-year window that they're planning on, or the legislation contemplates? Thank you.
Thank you. Ms. Little?
During the stakeholder consultations, it was our understanding that the State of the Environment reporting was going to get lined up with the environmental audit that happens, I believe, every 5 years. And that certainly made sense to us, and it made sense to others, that and best use of the data that's available and the the effort. So I think that that's the period that we were thinking, and making those connections with the environmental audit I think is fairly important.
Thank you. Further, Mr. Testart? Nothing further? Mr. O'Reilly?
Thanks, Mr. Chair. And thanks, Ms. Little, for coming here this evening. Maybe I'll start with the State of the Environment reporting, if I can. You've noted that there's a different time frame between the environmental audit that's conducted under the Mackenzie Valley Resource Management Act Part 6 and the State of the Environment reporting under here. The environmental audits every 5 years. In fact, I think they're out now starting to talk to people about the next one. And it is done through an independent steering committee that hires an independent auditor. The State of the Environment reporting in here is to be done internally by the minister and I guess his or her staff. And it's on a 4-year cycle. There's also a there's going to be some monitoring under the Forest Act in terms of the state of forests. I think there is like the transboundary water agreements that require monitoring. How would you propose then that this stuff be better coordinated or done in a collaborative way? Thanks, Mr. Chair.
Thank you. Ms. Little?
During the consultations, the discussions leading up to where we are now, there was a really strong push to harmonize all of the post-devolution legislation, and we strongly support that. And and you've been hearing from presenters here, and I'm sure elsewhere, that the Wildlife Act has got, kind of things that, we should be paying attention to, and the registry should be throughout all of the acts, all of those things. And I think that that is the lens that we need to apply to really come to grips with that question about how do we put all of these pieces together. Because we need to, they're all interrelated. And so that is, I think that is one of the big challenges for you folks as lawmakers and law keepers to make sure that there is that harmonization. And I'm sorry I can't be more specific than that, but I think that is the way to get to legislation that works and, eliminates those inconsistencies.
Thank you. Further, Mr. O'Reilly.
Yeah, thanks, and I appreciate your thoughts on that, and I think we're going to have to find some ways to, well, I can't speak for my colleagues. I'm interested in building in some legislative requirement for coordination and collaboration amongst these different sort of high-level, broad monitoring, reporting on in various environmental components or something. So that's something I think without a legislative requirement to do it, guess what, it ain't going to happen. So that's something, that's more of an asider from me. But I want to move on, Mr. Chair, to Ms. Little raised the issue of the enforceability, essentially, of the Statement of Environmental Values. And Section 18 of the Environmental Rights Act, the bill, says that, the minister of every department and body listed, and it includes things like Aurora College and BDIC, the Business Development and Investment Corporation, and so on, even the NWT Power Corporation's in there, that the head of, deputy head, minister of any department shall take every reasonable step to ensure that a statement of environmental values prepared or amended under Section 17 is considered whenever decisions are that might significantly affect the environment are made by the department or body. That sounds pretty strong, but there's not even a provision for public participation or review of a draft statement of environmental values. They just go off and develop them, and then they say that they're going to implement them. There's no public reporting. Any suggestions or ideas about how to increase enforceability or even basic accountability of these Statement of Environmental Values? Thanks, Mr. Chair.
Thank you. Ms. Little.
The words are not that strong, in our opinion. I think that there needs to be a requirement in this legislation so that we are ensuring that every public agency of the government of the Northwest Territories is protecting the right to a healthy environment. And in that requirement, there should be accountabilities. And given my understanding of the way this government works, wouldn't there be annual reporting of how that responsibility, that legal requirement is enforced? And that should be in legislation, not in regulation.
Okay, thank you. Anything further, Mr. O'Reilly?
Yeah, thanks, Mr. Chair. Yeah, just to be clear, there's no regulation-making authority in this act. It's pretty short, but I'm right on board, and there's not even basic reporting of how that's being implemented. So I'm interested in increasing the accountability there. You also spoke, though, to the need for, and I agree, some very fundamental changes to the way that this bill has been drafted. We heard from Ms. Collins a couple of nights ago, and I think you were here when I spoke about what the legislative process, how it works, and my colleague, Mr. Testart, also spoke of the minister having a veto. So I'm not sure we're going to be able to get all of the fundamental changes that you and myself and maybe others might be interested in pursuing. So you've also talked about climate change and our situation changing quickly and so on. Any other ideas about how we could find ways to improve this bill over time? And by the way, this was a very interesting bill because it actually came from a private member's bill in 1990. So this is the first time the bill's actually being significantly reviewed. So it's a very unusual piece of legislation in the first place. First time it's being reviewed, over 25 years or whatever. So how do we get a better handle on or more consistent review of this bill moving forward? Thanks, Mr. Chair.
Thank you. Ms. Little?
Thank you. You know, the NWT prides itself on being out there in front and doing really innovative things and being ahead of the curve. And I guess I have great hope for the lawmakers around this table and in the Legislative Assembly that you're going to continue with that attitude. And this is the kind of legislation that is truly needed at this time. Like as you're saying, Mr. Chair, that you're hearing about climate change and you're hearing about ecosystem change everywhere you go. This is one piece of legislation that gives some kind of assurance to individuals that their rights are being protected. And that, in this time, like I think that is a compelling argument to be made in the Legislative Assembly. This is election year. It's going to come up in everybody's election campaign, or it should, So this is an opportunity to really bring forth a piece of legislation, a law that is going to really look out for citizens and our ecosystem that we're part of.
All right. Thank you. Further, Mr. O'Reilly?
Yeah, thanks, Mr. Chair. I don't want to put words in your mouth, but I'm probably going to do it anyways. But I think your questioning and your comments have made me recognize or realize that we should probably build into this legislation a provision for a regular mandatory public review of it. And that does happen with some of our other legislation. Official Languages Act is one where there's a mandatory public review. And given changing circumstances and the fact that this is the first time we've reviewed this bill or this act has ever been reviewed, I want to build in a mandatory review. I'll raise it with my colleagues and see where I get. And then, of course, I have to sneak it by the minister maybe. But I think that's your questioning has been very helpful and has helped me formulate an idea about how to achieve that. So thanks.
Thank you, Mr. O'Reilly. To that, Ms. Little?
Yeah, I think that it only makes sense that be tied to the state of environment reporting at that time, because when we're looking at the dynamics of the environment, of our ecosystems, that really is an appropriate time and place to look at whether this legislation is meeting the needs and really protecting the rights of northern people to a healthy environment. Yeah.
Okay, thank you. Anything further? Nothing further? Anything further from committee? If there's nothing further, then I will thank you again, Ms. Little, for presenting on behalf of the Council of Canadians NWT chapter.
Great, thank you.
With that, I will put one more call out to see if there are any other members of the public that wish to speak on Bill 38, the Protected Areas Act, Bill 39, the Environmental Rights Act, or Bill 44, the Forest Act. If there is nobody further to speak on these bills, then I would like to ask committee if there is no further comments or presentations from the public. Do members agree that this agenda item is concluded?
Agreed.
Thank you. Thank you. So on behalf of committee, I want to take this opportunity to thank everybody for coming and presenting. I know that some of you have said to us that you appreciate that we're giving you this opportunity, but in fact it's us who are grateful to you It is a privilege to hear from you firsthand those concerns that you want to share with us on these bills. And so when we make our report in the upcoming sitting at the Legislative Assembly, we'll certainly be highlighting the feedback that we've received during these public consultations. So without further ado, I want to thank everybody once again, and we can be adjourned. Thank you.